Welcome to this pre-recorded webinar on the Great H-1B Shakeup of 2025. What's really going on and your questions answered. My name is Emily Sumner with Sumner Immigration Law, and I'm so excited that you've joined us for this pre-recorded webinar. We have gathered questions from our clients and contacts all around the United States and around the world, specifically questions about the $100,000 H-1B fee, and we have done our very best to answer them in this webinar. So we hope that you'll find this information helpful. So before we really get started, let's take a high-level overview of what we're going to be talking about in the webinar. Most of the information in this webinar will be focused on the $100,000 H-1B fee because it seems like that's what people have the most questions about, understandably. So we'll be talking about a high-level overview of the $100,000 H-1B fee, who is subject to the fee and who is exempt from the fee. Then we'll be talking about how this fee potentially impacts H-1B transfers, a change of status, H-1B amendments, things like that. We will then transition to talking about how the H-1B fee may interplay with the H-1B lottery coming up in the first quarter of 2026. We will be talking about then travel and reentry for individuals who hold H-1B status right now. And then we'll transition to some practical strategies for employers and foreign nationals alike. Some things to consider as you're planning, as you're finishing out this last quarter of 2025 and transitioning into 2026. We also have some questions, a couple of questions, specific questions from, like I said, our client base and contacts that we will answer. And I want to make sure that you know we'll have this information, more information at the end, but there's a lot of information here and there's a lot of information to analyze and to consider in planning your immigration filings. Again, whether you are an employer or HR professional and you're planning HR filings for the rest of this year and into 2026, or if you're a foreign national employee, there are a lot of questions, a lot of new information, and honestly, a lot of unknowns still. We totally understand that that can be absolutely overwhelming, anxiety provoking, and we are here to help. We are offering strategic assessment packages for individuals and H-1B readiness packages for employers. So again, we'll have more information about that at the very end of this slide or the end of this presentation, but just know that that is available. It's a way for you to have an in-depth one-on-one strategic session with me or Ashley, the other attorney in our office, to talk about your specific situation, your goals, and come up with a strategy for you in light of all of these changes to the H-1B program and other changes. We'll also talk about other options outside of the H-1B program, which there are. So let's talk about the $100,000 fee. What is fiction? So first of all, this is not fiction. The $100,000 fee is in process. It is a thing. It is reality. There was a proclamation that Trump issued on September 19th of 2025, and it's not an executive order, it's a proclamation. There's, in my opinion, not a big difference there, but my point is it was not done by regulation. But this was announced September 19th, 2025, and it is in play right now. So I've seen a couple of things online that have indicated that, oh, this is a proposal or it's not happening right now. It absolutely is. It is in effect. However, the good news is that finally a week ago, so I'm recording this on Monday the 27th, a week ago, Monday the 20th of October, we finally got some additional information from USCIS about how the $100,000 fee would play out. So we'll get to that in a minute. But here's some fiction, some things that I've heard floating around that are not true. Okay, and I know there's a lot of information out there. You're not sure what to believe. These pieces of myths, let's say, are not true. So it is the end of the H-1B program. I've heard immigration attorneys say that. Guys, it is not the end of the H-1B program, okay? We are here, we as immigration law professionals are here to support you, to help walk you through this. It absolutely is possible to still enjoy, not take advantage of in a bad way, but the H-1B program is so well and alive. It's not even on life support. It's not even in the ER, okay? We have a situation, the $100,000 fee, that absolutely we have to work around, but we absolutely can, okay? So the H-1B program is not going away. It has not died. It's not the end. Another myth that I've heard is you have to pay the $100,000 to file the H-1B petition or to get an H-1B visa. Maybe. That may be true in limited circumstances, and we'll talk about that. I've also heard that there's an exception for nonprofits. Unfortunately, there's not. Unfortunately, this fee applies across the board. I've also heard that the national interest waiver, which is a type of green card filing, is the same as the national interest exception. So, as you may know, as part of the proclamation, USCIS has said that there can be a national interest exception, and we have limited information about that. You can apply for an exception by submitting an email to an email address that they've provided. And they basically, the administration makes it seem like it's going to be granted very rarely. But I have heard people say before, oh, I have an approved national interest waiver petition, which is, again, a type of green card filing. So that means I have the national interest exemption and I don't have to worry about the fee. That's not true. It's not the same thing. So if you are in a situation where you are having to pay the $100,000 fee, know that just because you have an NIW approved does not mean you're automatically qualified for the exemption. So facts, let's talk about facts, reality for the H-1B $100,000 fee, who it applies to. Again, we got additional information finally on October 20th of 2025, and we're grateful for that. We obviously nobody wants to have to deal with this at all, but we're grateful for that information. So the $100,000 fee does apply to individuals who are in this, meet all of these criteria. The petition is filed on or after September 21st, 2025. On behalf of the beneficiary, that means the foreign national who is outside of the United States and who does not currently have a valid H-1B visa. We'll talk in more detail in a minute about what that situation actually looks like. But basically, it's for H-1B petitions that are filed for individuals who are outside of the United States and do not have a valid H-1B visa. It does not apply across the board to anyone and everyone filing an H-1B petition. It also could apply if you request, or it would apply if you request consular processing right away, or if you request a change of status, an amendment, an extension, and that isn't approved. So let's talk about those last two pieces for just a minute. If you request consular processing, so when we file an H-1B petition for a client, there on the forms, there are a series of boxes that we mark to indicate that we are seeking an extension of the status because the individual, the foreign national, already holds that status, a change of status because they're in the United States in a different immigration status like H4, F1, TN, any number of immigration statuses. Or we can request consular processing, meaning we want this person to go, we know that this person's going to have to leave the United States if they're here already, or maybe they're already outside the United States. They'll apply for the H-1B visa at the US consulate, and then they will enter. So if we are filing right away for consular processing, let's say that we have an employer, let's say it is an animal hospital, for example, filing for a vet who's located in England. They have never held H-1B status before in the United States, and you're requesting the very first H-1B for this person, then the $100,000 fee would apply if they are in England, not if they're in the United States in a different status. That's a different situation, and the fee probably does not apply. But if they're in England, have never held an H-1B status or visa before, then the fee would apply. Likewise, there are times when we request, and we'll talk about this again in more detail in a few minutes, there are times that we request a change of status, an amendment, an extension when we file, it's or one of those, when we file an H-1B petition. If that is not approved, if it's denied, and because it's denied, so the petition itself is approved, the H-1B petition is approved, but the change of status or the request of, the extension of status request is not approved, and the foreign national who maybe is in the United States right now has to then leave the United States, get the H-1B visa stamped, and then come back in, then the $100,000 fee would apply. So that's something to be aware of. So let's talk about when it does not apply. It absolutely does not apply if a petition, H-1B petition, was filed before September 21st. It says approved. I'm sorry, that's a typo. It's filed before 9/25/2020, September 21st, 2025. So all of the H-1B petitions that we filed for the H-1B cap and the lottery process in 2025, so you are registered in the H-1B lottery in March of 2025. We filed the H-1B petition between April and June. Because it was filed before September 21st, 2025, the $100,000 fee does not apply. That can be true whether you're in the United States and the petition is approved and then you go travel later, or it can be true if you're outside of the United States, but the petition was submitted, filed before September 21st, 2025, and that would include anyone and everyone who filed an H-1B lottery subject petition, because we have to have filed between April 1st and June 30th of 2025. In addition, it does not apply to current H-1B visa holders. And this is really important. This is clarification we have as of last Monday. It does not apply to a foreign national following a petition approval. It does not prevent that person from traveling outside of the United States and then re-entering. In other words, they would not have to pay the H-1B, the $100,000 H-1B fee if they were in the United States. And we'll talk about this in more detail. I keep saying that, but we will. There's lots to talk about here. If they were in the United States and we requested a change of status or an extension of status, and if that change of status or extension of status is approved, then the $100,000 fee does not apply, even if that person subsequently, after the petition is approved, decides to travel outside of the United States. It could be for work, it could be to visit family, any number of reasons. Even if you have to have the H-1B visa stamped again, the $100,000 fee does not apply in that particular situation. So this is great news. Like I said, none of this, the $100,000 fee I know is terrible. It's not good news at all. But the really great part is this really only applies to a very limited class of individuals. So again, if you're in the United States and your change of status or extension of status is approved here in the United States, and then you travel, you do not have to pay the $100,000 fee. We talked about this before just a minute ago, but it's what I just said. Petitions that request an amendment, change of status, or extension, and the beneficiaries in the United States, and if it's approved, the $100,000 fee does not apply. And again, the person can travel later, get the H-1B visa stamped and come in, and the $100,000 fee would not apply. It also does not apply to H-4 dependents or any other visa classification. So we've had lots of questions about that over the weeks since this has come out, since the proclamation was posted, and great questions. And the answer is no, it does not apply to H-4s, which are the dependents of H-1Bs or other visa classifications. So let's talk about the effect. We've had lots of questions from corporate clients and employers and even foreign nationals about how does the $100,000 fee potentially affect H-1B transfers or extensions, a change of status, an amended petition. All of those are types of H-1B petitions that we file throughout the year, regardless of the H-1B lottery that happens in March. And then we file those petitions that were the registrations that were selected between April 1st and June 30th. So putting that aside, we'll talk about that in a minute. But just your everyday type of H-1B filing, transfer, extension, change of status. As of right now, as of October 27th, 2025 at 2:29 Eastern, 2:29 p.m. Eastern, the government is closed. So we're not able to file, for the most part, we're not able to file this type of petition because the government's closed and we have to have the labor condition application from Department of Labor, and that's closed. USCIS is open, but Department of Labor is closed. So just keep that in mind that we're not able to file them right now. But it's not because of the $100,000 fee. It's because the government is closed and eventually, right, it will reopen. So once the government reopens, what can we do in terms of transfers, extensions, amendments, change of status? We can file, okay? So for H-1B transfers, for the most part, there are exceptions that we'll talk about. So for H-1B transfers, when you have an employee or a foreign national who's working for employer A, they want to change jobs and switch to employer B. If that person, that foreign national, is in the United States in valid H-1B status or other valid immigration status, and the petition is otherwise approvable, it's a position that is requires the minimum of a bachelor's degree in a specific field of study, meets the requirements. If that petition is filed as an extension of status, an amendment, or a change of status, in other words, as long as we do not request consular processing or border processing, that type of thing, and if it's approved, then that's fine. We can file the petition just like we ordinarily would, again, once the government reopens. No issue. You don't have to pay the $100,000 fee. And as I said before, even if the person later wants to travel, let's say that we file an H-1B petition on November 13th, just making that up. optimistic that the government will reopen by then. So we file it November 13th. We file it in premium processing. December 1st, the petition is approved. Awesome. They start working. This is a transfer, just making this up as an example. They start working as of December 1st for the new employer, and then they decide that they want to, over the winter holidays, that we celebrate in the United States, they want to go back and see their family. Awesome. Even if you have to have an H-1B visa stamped in your passport, a new one stamped in your passport, you can do that and would not be subject to the $100,000 fee. Now, I forgot to say this earlier, it's on the slide, but I forgot to say it, that none of this is legal advice, okay? This is for informational purposes only. And if you are in this situation, whether you are an employer, an HR professional, a foreign national, make sure that you talk with your immigration attorney before you make travel plans to make sure that you are not impacted. We want to know. We want to help you. We want to guide you. We want to make you as confident about this process as possible. Communicate with us and tell us if you plan to travel, and we will confirm for you that it does or does not apply. But generally speaking, like I said, once government reopens, H-1B transfers, we're good to go. We can file them without having to pay the $100,000 fee. H-1B amendments, the same thing. So an amendment is required when there is a material change in the terms and conditions of employment. So let's say that the work site changes to a different work site out of state or outside the original area of employment, and we have to file an H-1B amendment. No problem. We can file the petition as long as we request an extension of status, or it's possible to request just an amendment. I don't know why you would do that, but it's possible to not file an extension, not request an extension at the same time. But as long as you're saying this person is going to remain in the United States and keep working pursuant to this amendment, and as long as that's approved, then no problem. The $100,000 fee does not apply. Same thing for a change of status. I said a minute ago, we're putting aside the H-1B lottery. We do have clients who are H-1B cap exempt organizations. So they are universities and or certain nonprofits with affiliations or relationships with universities or institutions of higher education. Anyway, if you're a cap exempt organization and you're filing a change of status for a foreign national beneficiary from some other visa classification, it can be F1. That's common to go from F1 to H-1B, but it can also be any number of other types of status. So it could be H4, it could be J1 if they are otherwise eligible. There's a possible 2-year home residency requirement. Anyway, you can file a change of status from whatever classification you're on to H-1B, and you don't have to pay the fee as long as it's approved, as long as the change of status is approved. So that is excellent news. The key here is that whatever you're requesting, the change of status, the amendment, the extension has to be approved. If it's denied, like I said, if they approve the H-1B petition, but the extension or the change of status portion is denied, then the $100,000 fee would apply in that situation. Which is what I just said. If it's denied, and if you request consular processing, if you request consular processing from the get-go, then the $100,000 fee will likely apply. One thing to keep in mind, especially as the H-1B lottery season approaches in the first quarter of 2026, we do think that it's possible that we will see an increased level of scrutiny for any requests from that request to change of status from a different visa class or even extension. From extension of the H-1B or change of status request, it's possible that USCIS will really look at the person's maintenance of status. So that means things like, do they have pay stubs to show that they were paid if they're working on H-1B? Or if you're F1, do you have the documentation? Of course, the I-20s, but they could request other documentation to show that you are actually maintaining F1 status. That's especially a concern when a person has OPT, but even more so when they have had CPT, curricular practical training. And I have videos on Sumner School Business Immigration Basics, our YouTube series, about the CPT, and we also have blog posts on our website as well if you have questions about that. But bottom line is just know that it will be important that the maintenance is well documented and that they could ask about it. So H-1B lottery implications. Let's see what is, I'm going to stop this in case anybody makes anybody dizzy. Let's talk about what the implications are for the H-1B lottery. First of all, I want to say there are lawyers out there, I have seen them, who are saying this is the end of the H-1B lottery, that the H-1B lottery is not going to be used anymore, that it is impossible to file in the H-1B lottery. I've heard through the grapevine, nothing direct, but I've heard anecdotally that some employers are withdrawing their offers of employment for individuals that need to be sponsored for the H-1B. And that is not appropriate, and an employer can do that if they want to, of course, but that decision should not be made out of fear of the $100,000 H-1B fee. Okay. So if you are in that situation, if you're an employer in that situation where you have made an offer to someone and said, yes, we'll sponsor you for the H-1B in 2026 and the H-1B lottery, and you're concerned about the $100,000 fee, let's have a conversation. Okay. And see what that exactly looks like. Because it could be, like I said, if you are recruiting someone from overseas, then yes, the $100,000 fee probably would apply. But if the individual is here in the United States and if they ask for a change of status, when we file the petition, ask for a change of status, the fee should not apply, even if they travel later on. So that should not be a reason. And I know there are lots of, financial unknowns and that type of thing, but that should not be a reason to withdraw the offer of employment or H-1B sponsorship. I do think that what's happening is there are companies who historically have recruited really large companies, right? Like if I said the name, you would probably be like, oh yeah, I've heard of that company, but very large companies who hire hundreds or thousands of individuals on H-1B, new H-1Bs every year, or at least they put them in the lottery, and they're recruiting individuals from overseas. Those companies, of course, they're not going to be able to pay $100,000 for however many thousands of employees that they recruit from overseas every year. So yes, their programs will be impacted. But if we're looking at recruiting individuals here in the United States in a student visa status or L2, H4, any number of different visa classifications, then it's not impacted. The $100,000 fee does not apply. And there's no reason to withdraw the offer. This actually, again, the silver lining, I would never wish this $100,000 fee on, the system or the program. But it can create an opportunity, right? Because there may be individuals out there who had a job offer who thought their employer was going to sponsor them for the H-1B lottery come March 2026, and now that's changed because of this. It can be an opportunity for other employers, perhaps smaller employers, to connect with them and to find amazing talent here in the United States that wouldn't be available otherwise. So trying to look for silver linings here. So the key question with the H-1B lottery is, where is the foreign national employee? Like I said, if they're here in the United States in a valid immigration status, then the $100,000 fee absolutely should not apply. If they're outside of the United States at the time that you file the petition, so like I said, if you've recruited someone from anywhere in the world, it can be England or, Zimbabwe, wherever, it doesn't matter. A country of origin doesn't matter as much. But if they're outside the United States, then the $100,000 fee would apply. So you may need to change your recruitment strategy if that's something that you do frequently. The other consideration is travel while the H-1B petition is pending. So every year we have foreign nationals beneficiaries that we have entered in the lottery, created registrations for, they're selected in the lottery. Awesome. And then we file a change of status request from H-1B to from F1 or whatever their status is to H-1B. If you travel outside of the United States while that change of status request is pending, it's deemed abandoned and denied. That could be okay, except for this $100,000 fee. So every year, and this, especially in the summer, we have conversations. We warn clients up and down about this, and we have conversations about travel, the timing of travel. That will be absolutely critical this year, because if you make a mistake there, if you don't tell your employer or your immigration lawyer that you're traveling and the timing is not done strategically, and I'm not saying you can't travel at all, I'm saying we have to be very, very intentional and strategic and overly communicate. Because if you travel while the change of status petition is pending, the $100,000 fee probably would kick in at that point, and probably the employer is not going to want to pay that. So that's something to keep in mind. So we've covered the information that we have so far about the $100,000 fee. And like I said, there are a couple of questions we have at the end. I wanted to touch on a couple of other changes that we've seen in the H-1B program, or that relate to the H-1B program this year, and then what's coming up. So one change is there's no more Dropbox interviews. That changed as of September 2nd. So supposedly everyone has to have an interview for H-1B stamping or whatever type of visa you're getting stamping. In addition, no more third country visa stamping. It used to be that you maybe could obtain an appointment for a visa stamping in a country that is not yours. So right now, no visa stamping happens in the United States at all. There was a pilot program, you may remember, I think it was 2023, possibly into 2024. That pilot program ended and it is not a thing right now. So you have to get your visa stamped outside the United States. The Department of State rule now is basically that you have to do that in your home country. And then expanded social media vetting for, here it says for FM and J applicants. That was an announcement. There has subsequently been an announcement that they're doing additional vetting basically for all different kinds of applicants for immigration benefits. So that's something to keep in mind as you apply. And keep in mind what your social media says and other information that may be out there about you. So what may change or will likely change going forward? There are three key things that are related to the H-1B program. First is there's a proposed rule out for F1 and J1 visas. It is, I can't remember how many pages long the regulation is, but it's really long. There are a lot of changes that would affect the F1 and J1 visas. F1 is student visas. J1 is for intercultural exchange. So it can include interns, trainees, au pairs, short-term and long-term research scholars, that type of thing. Teachers, there's a program for teachers. My point here is a lot of individuals, foreign nationals, transfer or they change status from F1 to H-1B. So the changes that will occur likely in the F1 program will absolutely affect individual or companies that are recruiting individuals on F1. So the main thing to keep an eye out for here is there's a proposed rule that's out, the comment period closed. The agency is supposedly looking at the comments that were submitted and either incorporating those concerns or they'll address them in the preamble to the regulation that comes out. Anyway, probably the proposed rule will end the duration of status for the F1 and they'll put a hard limit, a fixed date limit on the admission for the F1. There are lots of other limitations to the F1 program that are coming into place. And when I say limitations, it's not anything that's like the end of the program. It's just making it a bit more tedious to ensure compliance. That's what we're here for. But it would require a change of status filings where that hasn't been required before in certain situations. Like I said, it would just make it a bit more tedious. There's also a proposed rule. So this proposed rule, the first one for Fs and Js, like I said, the comment period has closed. We don't know when the final rule will come out. It's possible it would come out this year in 2025. It's possible it would come out in 2026. We don't know at this point. When it comes out, we should have a notice period before the final rule becomes effective. We'll see. There's also a proposed rule for the H-1B cap weighted selection process. So as of right now, with the H-1B cap and the lottery that happens in March of every year, it's a random selection. Okay. Everything, all the selections are done completely randomly. So it doesn't matter what your job title is, where it's located, how good you are at your job, how much we need your particular occupation in the United States. None of that matters. How much you're paid, none of that matters. With the proposed rule of this weighted selection process, the wage level that is being offered to the individual beneficiary would make a difference in your in the possibility of being selected in the H-1B lottery. So in other words, right now there are 4 wage levels for H-1B. Wage levels, you have to, if you've been through this process before, the employer has to agree to pay a certain wage so that you're not underpaying foreign nationals. Anyway, wage level 4, there's 4 wage levels. Wage level 1 is the lowest wage level. Wage level 4 is the highest. And of course, there's 3 and 2. So this is an oversimplification, but basically, if an employer says, yes, I'm going to pay you wage level 4, that registration would have 4 entries into the H-1B lottery. If it's wage level 3, it'd have 3 entries, wage level 2, 2 entries, wage level 1, 1 entry into the H-1B lottery. Again, we don't know. The comment period for this just ended. We don't know. We don't have information on the timing or what this final rule is going to actually look like. I do believe that if and when this rule comes out, there will be litigation. There'll be lawsuits against it, and very possibly against the F1 and J1 rule as well. But it's possible that it wouldn't stand. It's possible that it would be implemented in time for the 2026 lottery. We just don't know, unfortunately. And I know that's not helpful for planning purposes, but we don't know. at this point. And then there may be a change, and the administration has said that they're looking at changing the H-1B wage levels. We don't have a lot of information as of right now as to what that means. The weighted selection process and the wage levels, the administration did try to change in the first administration, the first Trump administration, and those changes were struck down by federal courts. That does not mean that will happen again. I fully expect that there will be litigation, there will be challenges to this, but we don't know what's going to happen in the end. There could be some back and forth. So hang on to your seats. That's what we're here for, to help you walk through the process and navigate the process with as much confidence and clarity as possible. So that's what's coming up in the pipeline. So what do we do with all this information, right? There's so much information regarding the H-1B $1,000 fee, $100,000 H-1B fee, the proposed changes I just talked about, the changes that have already happened. What do we do? How do we proceed from here? The good news is we absolutely can still take proactive action now. So if you are an employer, an HR professional, global mobility professional, these are some things that some active steps, proactive steps that you can take right now. First is review a list of your upcoming expirations, H-1B expirations or other visa classifications, but H-1B expirations, any transfers that you have in the pipeline, any amendments that you need to file, so that you have that information ready to go for when the government reopens. It seems like today, on October 27th, something just, a flip was switched, and it seems like employers are like, I'm done with the government being closed. I'm going to go ahead and initiate these cases. We've had several requests today for initiating H-1B cases, whether that's a transfer, change of status, extension, things like that. So I know it's getting old waiting for the government to reopen, but it will reopen. And when it reopens, we need to be ready to have those petitions ready to file. So contact us if we're your immigration lawyer. If you need help and we're not your immigration lawyer, feel free to contact us. We'll have contact information on the outro slide after this, but you want to be ready to go. You want to be proactive and organized and ready to go. There's not a lot of I don't want to say there's not a lot of room for disorganization and chaos, but it certainly doesn't help anybody's stress levels. So the more you can plan ahead and be proactive, it can reduce your stress level, your beneficiary's stress level, and really help people to have confidence in the system and the process. In addition, if you are an employer, HR professional, that type of thing, review your list of potential H-1B cap cases, okay? So review that list and let's start thinking about now proactively. We can have a strategy session. Like I said, I mentioned the H-1B readiness package that we have for employers, but start thinking about who's going to be impacted potentially by the $100,000 fee. Of those individuals, what can we do? Is there another visa classification that we can think about? And that's true for others as well. Even if you don't anticipate that they would be affected by the $100,000 fee, the selection rate for the H-1B lottery for the past couple of years has been around 26%. So let's start thinking now proactively about other visa classifications that you can potentially use. And we have a video on our YouTube channel, Sumner Immigration Law, about alternatives to the H-1B cap. I think it was recorded in 2024. But that information still applies. So if you want to check that out, that's a good place to start. And then contact us. We're happy to help you walk through alternatives. But again, proactive planning really makes a huge difference. If you are a foreign national, here's some things you should be considering now. Where are you now? Are you in the United States? If so, awesome. Maintain that status in the United States. You do not want to fall out of status because then the $100,000 fee could apply to you. Plan your travel well. It's potentially okay to travel. Honestly, depending on your situation, it is likely okay to travel, but communicate clearly. Communicate with your company, with your employer, communicate with your immigration lawyer, and make sure they know when you plan to travel, for how long, where you're going, that type of thing. Let's have a conversation about it to make sure that you're set and that you're going to be able to come back without having to pay $100,000. And then if you are in the US in perhaps F1 status or another classification and you're thinking about the H-1B lottery in 2026, absolutely keep that in your list of options for sure. But know that there are potential other options as well that we can talk about. And if you've been here in the United States in H-1B status for a while, or even for a few months, it's October, or even a few weeks, it's October 1st, If you've only been here for 26 days in H-1B status, start thinking ahead, start thinking about long-term plans. And if you need to start that green card process so you can extend your H-1B status beyond the 6th year, there's a limit of 6 years in H-1B status, or if you need to extend, change your, if you need to file for a green card so you can stay here long term, is what I'm trying to say. So plan ahead, which is a great segue to our next points here, right? So what do you do? And this applies to people, whether you are an HR professional, a small business owner involved in global mobility, or a foreign national, or somebody who loves a foreign national, or works with, cares about a foreign national. Plan your filings early. This is not a situation or the environment where you want to wait. Okay, I know we have to wait right now because of the government shutdown, but plan ahead as much as you can. Keep your documents current and organized. This applies to both employers and foreign nationals. For foreign nationals, if you could create a file of a secure file of things like your birth certificate, marriage certificate, divorce decrees if you have them, proof of status, pay stubs, things like that. And then you were able to send that to your immigration lawyer when we need to file an H-1B extension or a green card application. That would just be a dream come true. And it would make the process a lot easier for both you and us and faster. So keep that in mind. Maintain status, like I said, stay informed, but don't panic. If you see something and in the news or online or on TikTok, heaven forbid, or Reddit, and you think, oh my goodness, this is terrible, I'm going to be deported tomorrow, take a deep breath. Feel free to send it to me. I am on LinkedIn. Feel free to DM me on LinkedIn or send us an email, whatever it is. If you're a client or not, send it to us. And to the extent that we can, we will advise you. We will help you understand what it really means and if it applies to you or not. If you're not our client, you may have to set up a consultation so that we can get your information, your background, and see if it applies. But I'm happy to do that. There's so much information out there, and we don't want anyone panicking without need because a lot of times it's just not necessary. Likewise, don't rely on rumors. Very similar to what I just said. Do not compare your situation to your cousin's, neighbor's, uncle's cat's previous owner. Okay, I hope that made you laugh. But there's so many situations where we have clients or prospective clients who have talked to, their cousin's, neighbor's, uncle's cat's previous owner, and they had X outcome. Well, guess what? It was 10 years ago. They're from a different country. It's a totally different filing process that they went through. It's just, you cannot compare. I know that's easy to do. I know in my personal life, I have compared for sure, not immigration, but other things. It's human to want to do that, to want to talk and connect and see what's going on. But please don't, because it's not helpful generally. Don't assume. Communicate with your employer or your employees if you are the employer, and communicate with your lawyer, even if you don't think it's something that we need to know or that's important to ask about. Just do it. Okay, we do not mind. We at Sumner Immigration Law, we would love to hear from you, especially if you're a client and have information that is actually doesn't matter, that's not relevant to your case. That's fine. We would rather have that and say, oh, that's fine, thanks for letting us know, than not having the information and then finding out that you've taken some action that is really detrimental to your case. So if in doubt, communicate. Likewise, don't travel internationally without confirming it's okay, and don't lose hope. I know these are difficult times if you are employing foreign nationals or if you are a foreign national here in the United States living and working and just trying to live your life. And I know it seems overwhelming and like perhaps people don't want you here in the United States. Perhaps that's true, perhaps some individuals do not, but the vast majority of people here, of US citizens and green card holders, we want you here, not just because you add to the economy or the professions or any of that. That's great, and absolutely that's true, but you also add to the richness and the diversity of the country, and we are so glad that you're here and hope that you stay. So don't lose hope. We are here to help you navigate these things. So questions, two questions that we'll talk about. One is, and this is an actual question from a client. I have a beneficiary who is currently in the US on OPT status. If they're selected in the 2026 lottery after their petition is approved, if they travel to their home country for visa stamping, will they be required to pay the $100,000 fee upon reentry to the United States? The answer in this situation is no. If they're in the United States on OPT, so they, in this case, we register them in the H-1B lottery, they're selected, awesome. We file the H-1B petition. They're in valid OPT status. We include the documentation of their maintenance of status. So, for OPT, things like their I-20, copy of their actual EAD card, pay stubs, things like that. And it's approved. Let's say the H-1B petition is approved. The change of status request from F1 to H-1B is approved. And then their H-1B status begins October 1st of 2026, right? And then in whenever it is, January, March, whenever it is of 2027, I mean, there's no specific waiting period, but after it's approved, they want to, whatever it is, go to Mexico for vacation or they need to present something at a conference in London, or they need to go home and visit family, or they want to go see their mom. Please go see your moms. Then yes, they can travel and they should not be subject to the $100,000 fee. The second question is, I filed a change of status from H-1B to B-2 last year. So this is the opposite, right? They were on H-1B status and now they have filed a change of status to B-2, which is a visitor's visa status, and it was approved. Great. The question is, can I now transfer back to H-1B through self-sponsorship? The answer is yes, if, right? So if this person says that the B-2, the change of status to B-2 is approved, so as long as that's still valid, the I-94 has not expired, and you file a change of an H-1B petition with a change of status request to self-sponsorship, yes, as long as that change of status request is approved, the petition's approved, the change of status is approved, that's fine. And you absolutely can self-sponsor for an H-1B. That's always been the case, but there's new regulations that came out in January 2025 that clarified that a bit in the regulations. And yes, there are certain things you have to show. You have to show that it's actually a bona fide and operating company. You have to show that you will be doing work that is H-1B work, not answering the phones and processing mail. And you have to show that you will be able to pay yourself, to generate profit, to pay yourself, or money to pay yourself. But it absolutely is possible to do. So we're wrapping up here. Like I said before, we are offering strategic assessment packages for individuals and H-1B readiness packages for employers to help you walk through these considerations in more detail. Like I said, it would be a one-on-one strategic session with either me or Ashley, the other immigration attorney. We would have a questionnaire ahead of time to gather information on your current situation, your goals for being here in the United States, and other critical information that we would need to have. We would have an in-depth conversation, and then you'll walk away, or at least not literally, but we'll send you within a week a PDF that outlines different options that you have available based on the different possible outcomes with the regulations that we have pending. So we have the $100,000 fee right now. Thankfully, we have additional information. So the walkaway package, the PDF that you have with outlining different options, absolutely will take into consideration the $100,000 fee, but it will also take into consideration the implications of these pending, proposed regulations that are out there. So we know that there are a lot of unknowns right now, but it absolutely is possible to plan ahead now, to be proactive and come up with a plan and feel confident about stepping into 2026, filing an H-1B. So elements for success. What are your long-term goals? Think about what your long-term goals are. Be willing to be flexible and think outside the box. Not, you may enter the United States with a specific plan in mind, and you may take a path that doesn't it gets you to your end goal, your original end goal, but it's not the path you anticipated, and that's okay. Things change. And then find an experienced immigration lawyer that you trust and that you feel comfortable with. That's critical. It's critical to us as immigration law professionals at Sumner Immigration Law that our clients feel comfortable. They feel like they know what's going on. They feel educated as much as they want to about the process, and that they feel confident about the process that they're going through. This is a way that you can stay in touch with us, learn more. So if you scan this QR code, it will take you to a web page on our website that includes links to our YouTube page, my LinkedIn page, my personal LinkedIn page. I post there usually 3 times a week. I go live on Tuesdays as well. Feel free to connect with me there. It also links to our Instagram and Facebook page, of course, our website. We also send an email newsletter once a month, the first Wednesday of every month, an email newsletter to anyone and everyone on our list. So we hope that you will connect with us in one or more of these ways that you feel comfortable with. My name is Emily Sumner with Sumner Immigration Law. We serve clients around the United States and around the world, does not matter where you're located, with family-based and employment-based immigration matters. If you are a current client, thank you so much. We really appreciate you being a client. We hope that you feel confident in the process that you're going through, and we're happy to answer questions. If you are not a client yet, but you need assistance, your company needs assistance, you need assistance, feel free to contact us. First step would be to set up a time for a consultation to talk with us, not about us, but to talk with us about your situation so that we can come up with a plan. And it can be that strategic assessment package that we talked about, or it can be a general consultation, depending on what your particular needs are. So the strategic assessment package that I mentioned, there is a this website, and I think it's linked, but anyway, this is the website. If you copy this, it will take you to the information page about that. So I hope you have found this information helpful. If so, I hope you will share this recording with a friend or a family member and stay in touch. Until next time, my name is Emily Sumner.